All right, the next case on the calendar is Jeffrey Carey versus First American Title. Whenever you're ready. Oops, wait a minute, let me set the clock. How much time would you like for rebuttal?
I'd like to save 5 minutes for rebuttal, Your Honor. May it please the court, my name is Matthew Herman on behalf of the Herman Law Group. I represent 47 appellants before this court, known as Herman's plaintiffs below. This is my first oral argument at the district court level, so please bear with me. I appreciate the opportunity. It is undisputed that First American and United General, the insurance companies in this case, appointed Lake Title as their policy issuing agents. It came from the answer brief at page 10. Lake Title was a licensed title insurance agent pursuant to Florida Statute 626-8417, took the appellant's deposits, acting as an authorized escrow agent for the title insurers under 626-8473. This subjected their title insurers to proportional liability under 627-792, the Florida defalcation statute. And that is why we're here today on a seeking reversal of a summary judgment that was granted against Herman's plaintiffs. The Supreme Court has stated it is reasonable to conclude that by enacting 627-792, the legislature intended to create an avenue of relief for victims of non-attorney title insurance agents that otherwise did not exist. That is what we have here. We have a non-attorney title insurance company.
Is there any evidence that appellees acted in any way other than an escrow agent in this case?
No, they acted as just an escrow agent. That's all that is required under the statute. In order to act as an escrow agent under Florida law, Section 877.101 requires that you be either a financial institution, an attorney licensed with the Florida Bar, a Chapter 475 broker, which is a real estate brokerage firm, or a title insurance agent. They were acting as a title insurance agent. They've always acted as a title insurance agent. And a title insurance agent is defined under statute 626-841 definition. This is not a Black's Law definition. This is the statutory definition.
So was there any role that Lake Title took on to act or at least assume the duties of an underwriter at any point during any of these transactions?
They would take the deposits on behalf of the underwriter. The only way under Florida statute 718.
So were they acting in the shoes of the underwriter?
They act as the underwriter's agent. So yes, they act in the shoes of the underwriter. And under 718-202, the condominium statute addresses this question that says every escrow account required by this section shall be established with, and it gives a list of how they can establish these accounts. A bank, Lake Title's not one. A savings and loan, they're not one. Florida Bar, again, comes up. It's the same list. A real estate brokerage account. The key is the point where it's 718-202 says a title insurer authorized to do business in this state acting through either its employees or title insurance agents under 626, the Florida insurance statute. Lake Title was acting through its title insurer, First American and United General. And title insurer is a defined term. Title insurer means a domestic company organized and authorized to do business under the state of Florida under 626, which is the insurance statute. This then implicates them under 627-792, which is also part of under the insurance code, for liability of their insurers for defalcation by their title insurance agents or agencies. Where a title insurer is liable for the defalcation, conversion, misappropriation of its licensed title insurance agent or agency for funds held in trust pursuant to 626-8473. It's the only way they can take money, take deposits legally. the panel have any questions of me?
Well, I think I might. The judge made some findings, looks like 7 of them, findings of fact, which she said were undisputed in the final judgment here. Do you disagree with any of those, that those were undisputed?
The only finding I disagree with here is in the order, Part F, it's at record page 2679, where is a legal conclusion that Lake Title did not hold deposits in trust pursuant to 626-8473.
All right, but paragraph C, I through 7, or 1 through 7, you agree with all those? Those are undisputed facts?
Let me.
None of your,
Yes, I don't think that, if Your Honor's question is there a factual issue here? No. We're not stating that there's a genuine issue of material fact that this
you
should
just
come back on.
disagree with the legal conclusion from these facts?
Exactly.
Okay.
There's no actual factual dispute here. It's a legal conclusion that is wrong. Unfortunately, the lower court judge was wrong on the law.
Any other questions? No? Okay,
I'll reserve.
certainly.
Good morning. May it please the court, my name's Brad Luzak. I represent First American Title Insurance Company and United General Title Insurance Company. The key question in the case below in this appeal is whether the escrow funds were funds held pursuant to Florida Statute Section 626.8473. And so in order to answer the question below and the question here, we have to figure out what are funds held in trust by the agent or agency pursuant to that statute. And I would respectfully suggest that in order for the funds to be held in trust pursuant to that statute, 3 things need to happen. The title insurance agency that's holding those funds must first be an escrow agent. The title insurance agency holding those funds must second be holding those funds in connection with a closing that title agency is going to handle. And then thirdly, the title insurance agency must hold those funds in connection with a closing in which it will issue a title insurance product. In the facts at hand, the Lake Title, the agency that allegedly misappropriated the funds, was undoubtedly holding the funds as an escrow agent. Holding the funds as an escrow agent alone is not enough. The Lake Title had to wear 3 hats: escrow agent, title agent, and closing agent. It wore undoubtedly 1 hat, escrow agent. It did not, however, wear the other 2 hats, closing agent and title agent. And there simply is no genuine issue of material fact as to the lack of title agent and closing agent hat for Lake County. Now, Judge Berger, you indicated that the appellees acted as escrow agent in the question you asked a little earlier. I don't want to be too nitpicky, but Lake Title acted as the escrow agent. What's important here, and the reason I'm being nitpicky, is that a title insurance agent is the agent of the underwriter for very limited purposes. The title insurance agent is only the agent of the underwriter for the purposes of issuing policies, commitments, and endorsements. And if I were to go a little further than the case law has gone, I would suggest also for collecting premiums. A title insurer is not the principal of the title agency, however, for the purposes of conducting closings and holding escrows, which is why we need a statute such as the defalcation statute in order to impose liability on the title insurers for these acts that are outside the scope of the agent's authority. Otherwise, there would be liability under common law principles such as respondeat superior, if I said the Latin nicely. Judge Wallace, you were, as I understood your question, absolutely correct that the other things that Lake Title did weren't part of the relationship with the underwriters. As far as the underwriters go, First American and United General, the Herman's plaintiffs had no relationship whatsoever with them. None. There was no agency, no services provided to them, no consideration paid to them. They are strangers to each other. And then Judge Harris, I would echo what you said. There simply is no genuine issue of material fact here.
Don't you argue at some point that we don't really know what the relationship was because we don't have all the contracts? The judge didn't have all the contracts?
No, I don't think that's an accurate description of the argument, but rather the argument that was made is we don't know all of the material terms of the escrow arrangement. Recall that there's no dispute that Lake Title was the escrow agent pursuant to a written agreement, a tripartite written agreement. Part of that written agreement is embodied in the contract for sale and purchase, but the contract for sale and purchase incorporates by reference another document, which candidly I've never seen. I don't know whether anybody has a copy of it. It isn't necessary to know all of the terms of the escrow arrangement to determine this case. We concede that Lake Title held the funds as an escrow agent. It doesn't matter what the terms of the escrow agency were. The keys here are not that it was Lake Title was the escrow agent. The keys here are that Lake Title was never designated as the closing agent, nor was Lake Title designated as the entity who would sell the title insurance products.
But this was a pretty fact-intensive analysis that the judge had to do. Would you agree it's pretty unusual to resolve a case like this by summary judgment?
No, sir.
Because the Winkler case was a deck action like this one. That went all the way through a non-jury trial. The Cohen case that you rely on, that was an appeal of a order dismissing.
Correct.
Do you have another one that was resolved by summary judgment?
No, sir. In fact, I think the universe of defalcation statute cases is rather small. There's only 3 principal cases, as I recall, Heckman and the other 2 you've just mentioned. So, no, I'm not aware of any others that were resolved by summary judgment, but there's only the 3 of them. That doesn't mean that this wasn't an appropriate case for resolution by summary judgments because there simply was no genuine issue of material fact regarding whether or not Lake Title was designated as either the closing agent or the title insurance seller or vendor. Lake Title was not, because Lake Title only wore one of the 3 necessary hats. The summary judgment was appropriate, and we would ask that this court affirm the summary judgment below. I've asked for what I want. I forgot or neglected to ask you if you have any questions for me.
Any questions? Nope. Thank you very much.
Thank you.
What evidence is there in the record that Lake Title acted as either the closing agent or title agent?
The closing agent or the title agent, as to a title agent, there is reference in the contract that title insurance will be purchased by the developer and given to the buyers. However, under the contract and under the statute doesn't require that they were designated or that anybody was, they were definitely definitively told that here's who's going to do the title insurance. The reason for that is if they were designated, we wouldn't be here. If they were designated, you'd be under the 627-792 defalcation, the second part of the statute, where it's non-proportional liability. It's 100% liability for those insurers who issued, title insurers who issued. That was the case in Cohen. Cohen went through, Cohen is almost very, very factually similar here. The difference in Cohen was the underwriter in Cohen actually issued a policy. So the damages or liability was put onto the underwriter who issued, and that's what the statute contemplated. The statute doesn't talk about all of these other terms that are being read into this statute. It's very clear. All you have to be is an escrow agent. The designations aren't part of the statute. The escrow agent is, and a title agent and a closing agent. The issue you get to on the closing agent is found under the brokerage statutes at 475, and it's a commercial real estate brokerage statute. You won't find closing agent in the statutes that govern here, their statutory structure that governs here. As for any factual issues, the escrow agreement that keeps being tossed around or talked about, they don't know what it is. The judge wasn't available to have it.
But they admit that it was held in escrow by Lake Title, so I mean,
And that's all that's
what's the
required.
point of it?
There isn't one. And that's all that's required. Because if you go under 718, where that escrow agreement would be originated, there's only two ways under 718 you can hold an escrow. 718-202, the developer shall pay into the escrow, into an escrow account. 718-202-6, a developer shall pay into an escrow account. The difference is one will become a sales agreement versus a reservation agreement, not in dispute here. Under 718-202-8, again, a title insurer, a defined term. It was First American United General, authorized to do business in this state acting through either its employees or its title insurance agent licensed under 626. Lake Title is a licensed insurance agent under 626. So they are governed then under 626-8473 as holding an escrow because it's the only way they could hold an escrow. Nobody's mentioned here how else could they hold an escrow. You can't pick somebody off the street and have them appointed your escrow agent. It doesn't work that way because it's regulated by the state of Florida. Unless you're a financial institution, a lawyer, or a person licensed pursuant as a brokerage firm, or a title insurance agent. Again, defined term, title insurance agent. Lake Title was acting on behalf of its underwriters. But in this case, there's no evidence to suggest they were acting as a title insurance agent in this case or acting as a closing agent in this case. The only evidence in the record is that they were acting as an escrow agent in this case, correct? No. They had to act as a title insurance agent.
Where in the evidence, where in the record does it say that Land Title was acting, or Lake Title, was acting as the closing agent or the title agent?
The closing agent won't be there. There's nothing to that effect, and the title agent is a defined term.
But where in the record does it show that Lake Title was acting as a title agent for the appellants in this case?
Title agent for the appellant. They weren't acting as a title agent for the appellant.
I mean, or for the appellees, I'm sorry. Oh, or where does, In this case in general, then, where does it show that Lake Title was designated as the title agent?
It's not, if you need the term designated in the first part of the contract, they're under the purchase on page 2 of the contract, there is an inclination there that does say the word designated, but again, designated is not what we're here for today. Designated.
Well, it is in terms of, for us determining whether or not you're entitled to some relief on appeal. I mean, just because an individual can act in some capacity in some point in time as a closing and title agent and an escrow agent doesn't mean that they're acting in that capacity in a particular case unless the contracts or the evidence suggests it or points to it. So I'm just asking you to tell me where in this case it points to the fact that Lake Title was acting as a title agent. You say it's not acting as a closing agent, so, there's nothing in the record to suggest that. So I'm just asking for a specific place in the record where it shows that they're designated as the title agent.
If I may, Your Honor, title agent is a defined term under the statute. It's the only way they could act. They don't need to designate them as a title agent at the contract stage or say anywhere in this record that they were a title agent, because Lake Title is a title agent. It's the only way it could act under Florida statute. You're not going to see in the contract or on this record that Lake Title was the designated title agent, that Lake Title was the title issuing agent. But
Could there have been some other company that was the title agent or to issue the title policy in this case?
It could have been, and that would have been the facts under Cone, where they had the monies taken in by one title company, and then another title company actually issued the policies. In the interim, the company that issued the title insurance policies didn't check for make sure the escrow deposits from the first title company were still there. So it was rightfully the liability was placed with the title insurance company that issued. If the purpose of this statute is for when there isn't an issuance that occurs, because people put their money with a lawyer, they expect that there's some trust with a lawyer or some kind of, slush fund at the Florida Bar for escrow defalcation. There's money up there. They have a defined term. I don't call it offhand. They expect with a brokerage firm, there's regulations, there's money. The other thing that falls in there is you could be a financial institution with a value of $5 million or more. You could be an actual bank, Bank of America, something like that. So when you come to a title insurance agent, you're acting on behalf of the insurer. Again, 718-202 says that the escrow is established with the title insurer. The escrow is not established with a Lake Title or with a bank. It's with the title insurer. That's why they spell out bank first, Florida Bar. My escrows are with me. I go to a bank to put the money in there, but they're with me. It's the same thing with a title insurer. The title insurer, the money that they put up to do these projects is with the title insurer. They go to a bank or they go to an agent to put it in the bank to maintain it, but the actual escrow itself is held because they're a representative agent of the title insurer, and the insurer would be what most people commonly know as the underwriter. Any other questions for me?
Nope.
Thank you, Your Honors. I appreciate it.
Thank you.
Thank you.